Go ahead, Stephen.
Hey, I have a question for Kevin. My wife and I, our family, got a threatening letter in the mail from an attorney on a house that we owned 5 years ago. We did some improvements to the house. We hired contractors to do such. And those improvements happened 7 years ago. So we sold the house 2 years after those improvements. We moved up to Northern California. We got this letter in the mail saying that I misrepresented our purchase contract and said we removed and reinforced a non-load-bearing wall. And in fact, it was a load-bearing wall. And so they're claiming that we lied to them and tricked them into buying the house, and they would never buy it if they knew it was a load-bearing wall. We went off of what the contractor said. The contractor did it in, a day, didn't pull permits, so therefore, he made us believe it wasn't a load-bearing wall. It didn't need permits. And long story short, they're coming after us for $40,000 on to fix the issues of the house, and they're threatening a lawsuit, and we have mediation on November 5th.
Damn.
Well, the upside is they're only asking for $40,000.
That's a lot.
And I say that with some levity because there's no way out of that situation.
For who?
For him.
For the caller?
Yeah, because any purchaser can say what he's talking about when they say that they said they wouldn't have bought. They're setting him up for a fraudulent inducement claim, saying you failed to disclose, and had I known, I would not have gone forward with this deal. Therefore, rescind it, take your house back, give me my money back.
Whoa.
That's kind of a hollow threat at this point because they're not going to give the house back and they're not going to unwind the contract. But $40,000 in a litigation context is not a lot of money. So,
and when they're going to mediation, is that some type of regulated by some type of real estate mediation, or is that just two lawyers sitting down with their clients, or do you know? Typically,
for California standard purchase and sale contracts, there's a mediation provision in it. I hate it. It's awful. It's awful. But so they're required to take this step before they go to court. So they can agree on a mediator of their choosing. They can go hire JAMS or AAA or some other mediator to just sit down and try to broker a deal.
But if Stephen was your client, based on what you've been told here, you would advise him be expected to pay something.
Yeah, I would push back. I mean, I would be aggressive. It sounds like he's got the facts on his side, and one of the reasons why I said there's no way out for him here is because if there was something wonky with what happened, he's now going to have to call the contractor and say, you screwed up. Now you pay me because I got to pay them.
Oh,
and that's
boy.
a whole other set
right.
of
It's just going to get a mess.
All right.
So, and then there's also the brokers. He's going to say, well, what did your broker tell you? What did my broker say? So it would be cost effective to just sit down in the mediation. You're required to anyways if they demand it. And if there's a reasonable number that can be arrived at, you should probably just pay it.